Have you heard about this doctrine of impossibility? None of you. Have you read Contract Act? There is section 56 in the Contract Act which talks of impossibility in the
So yes, sir, we
performance.
remember, sir.
You,
Actually, I remember.
you remember?
Yes, sir.
Recently, this doctrine came in the news. Have you read? Allahabad High Court gave certain directions to the state government, and the state government took the plea that it is impossible to be carried out. It went to the Supreme Court. The Supreme Court said that the doctrine of impossibility applies to court's order as well. While issuing directions, the court should be conscious that whether the directions are capable of being executed or given effect to or not. This was the case of state of UP versus inhuman conditions at quarantine centers and for better treatment of corona positive. The direction was that all the medical colleges of the state of UP should be brought to the level of Sanjay Gandhi Institute of Medical Sciences, postgraduate medical sciences, within 2 months. Then it said that all the grade B and C towns should be provided with 20 ambulances, and every village must be provided with two ambulances. Yes, Aishwarya has read perhaps. 2 ambulances, and that has to be done within a period of 1 month. The court said that despite best intentions, we are not able to do it. So therefore, and if our officers would be hauled up for something which they are not able to do, that would not be good. The Supreme Court granted indulgence and stayed the order of the High Court and said that before issuing any directions, kindly see to it that whether the directions are capable of being implemented or not. So henceforth, this will act as a restraint on High Court's order, where people will start raising this plea, particularly states, whenever it wants that I don't have to carry out. He says that it's not possible for me to do it, and now they will cite this judgment. So this is for the first time. Earlier, for the performance of contract, impossibility was there. The doctrine of impossibility was there. But for the court's order, this has been said for the first time. And let me tell you something about Section 56 also. The Section 56 says that it conceives impossibility at 2 stages. One is at the time of entering into contract. And it says that if you agree to do something which is impossible to do, then your contract is void. And it gives some examples that if the illustrations are given in the act itself. It says that if A agrees to bring treasure by magic, then the agreement is void, but because it is impossible to bring treasure by magic. Then another example is that second is that subsequent to the entering into contract, you entered into contract, at that time everything was all right, but there is some subsequent event which prevents you from executing the contract, and if you are not responsible for that, and if it is beyond your control, then also the doctrine of impossibility will come into play and the agreement would be void. The act gives the example that if A agrees to marry B, and before the date fixed for the marriage, goes mad, so the contract would be void. It was not conceived earlier. At the time of entry into agreement, it everything was all right. Another example is says that if A agrees to give some cargo to country B, and after the agreement was executed, the country B declares war against the country A. So the agreement could not be given effect to, and then the agreement would be void. This is the doctrine of impossibility as said in section 56.